Hi everyone, my name is Siani Tolbert, and today I will be evaluating Priceline.com terms of use today. The legal basis of users dealing with Priceline website is outlined in this important document. Key elements of the agreement will be discussed, such as legality as a contract, the terms, binding effect on users, the dispute resolution procedure, and lastly, suggestions for possible enhancements. Well, let's just start by talking about whether Priceline terms of use are legally binding agreement. A contract must satisfy the following legal conditions in order to deemed valid: offer acceptance, consideration, consent of both parties, and legality. Priceline satisfies the offer criteria. Its terms use are portrayed as a legally enforceable contract between the company and its users. The acceptance condition is met by people who use the website, implicitly accepting these terms. The use of Priceline services is a compensation in this case, and the terms specify mutually obligations, mutual assent. The terms meet the legality requirements since they regulate transactions that are allowed by law. Therefore, I conclude that Priceline term presents a valid contract. So let's now discuss how users are required to abide by this agreement. Priceline now uses a browse warp agreement, which means that by using the website, users are considered to have accepted the terms. This approach, however, may provide issues because it depends on users being aware of the term existence and binding nature. I suggest changing the contract to a click wrap agreement in which customers most actively click I agree before completing any transactions in order to increase the enforceability of the agreement. In the event of a legal challenge, this approach guarantees that users have been made aware of the terms and have given their active agreement. Now, for dispute resolution, Priceline terms of use states that users consent to binding arbitration as a means to resolving disagreements rather than going to court. This implies that you are unable to file a lawsuit against Priceline in a conventional court of law if you and the company cannot agree. Online agreements frequently contain arbitration clauses since they are less expensive and time-consuming than going to court. This usually waives the right to a jury trial and restricts the user's capacity to file a case. Priceline is essentially protected from class action lawsuits by the arbitration provision, which may be interpreted as a restriction on customers' rights. Lastly, I would like to suggest a few modifications to improve Priceline's terms and use in terms of justice and openness. First, we was already indicated putting in place a click wrap agreement would guarantee that customers understand the condition completely and agree to them. Secondly, I propose that the arbitration clause should be reviewed. Arbitration may not always be in the best interest of customers, despite its potential for efficacy. By providing an opt-out clause for arbitration within a reasonable time frame, the corporation and its users' requirements needs could be balanced. Finally, I suggest making the terminology more straightforward. More clear wording would make the document more accessible to all users and increase platform confidence, as legal jargon may be intimidating. In conclusion, Priceline terms of use are a valid contract and effectively governs the relationship between the company and its users. However, by making some key changes like opting a click wrap agreement, revising the arbitration clause, and simplifying the language, Priceline can make its terms more user friendly and legally robust. Thank you for watching, and I hope this evaluation has provided value insights into the importance of clear and fair user agreements in the digital age.